I will now call 495, State of Kansas versus Mika Thille.
May it please the court, I'm Ryan Ettinger, Assistant Appellate Defender, appearing on behalf of Mika Thille. With the court's permission, I'd like to request 3 minutes for rebuttal, please.
3 minutes is reserved. Thank you.
Thank you. A Sedgwick County jury in this case convicted my client, Mr. Thille, of a single count of reckless second-degree murder. Importantly, the jury also acquitted Mr. Thille of felony first-degree murder, second-degree intentional murder, and first-degree attempted murder. The issue that I brought before this court in our petition for review as a follow-up to our appellate brief is that the Court of Appeals erred in affirming the district court's denial of a requested lesser included offense instruction for voluntary manslaughter. Of course, this court knows that voluntary manslaughter is a intentional killing done in one of two ways statutorily, either upon a sudden quarrel, the heat of passion, or upon an unreasonable but honest belief that circumstances existed requiring the use of lethal force. What I've argued here and what I want to argue before the court this morning is that the facts in this case were sufficient to satisfy both of those components, either form of that offense of voluntary manslaughter. The facts in this case were that my client, along with several other people, approached this. We're searching for my client's brother, Max Thille, who had disappeared with apparently his girlfriend or partner's bag. And he had gone to this residence well known as a drug house. This house is full of people that are all, for the most part, what we can tell is they're all consuming methamphetamines and heroin. Max is in this residence. My client gets a call that Max has gone to this house. He's sort of hiding out there. And my client, Mr. Thille, along with a couple other people, including the person whose bag had been taken, Valerie Vogel, and somebody who's known as One Hit, as well as my client Max, and then Max's girlfriend. My client Mika and his girlfriend Kayla. So they go to this house, and here's where this case is very difficult because every single witness in this case has some sort of different recollection, and I would say vastly different in some regards of what exactly happened at that time. And that's why I think everything at this point really became a question for the jury to sort out exactly what was going on here. Who's credible, who's to be believed in this situation as far as what happened. There was testimony that there's yelling at the front door. There's testimony that Micah went to the front door to ask, where is Max? I guess Valerie was screaming something about, I want my bag back. So there's a confrontation either at the front door, on the porch. There's even some question about whether these people were in, like, not necessarily Mr. Willingham, the victim in this case, but the other participants in this incident, whether they were even on the porch, whether they were standing in the yard. So the argument is that when these facts are viewed in the light most favorable to my client Micah, that there was sufficient evidence here to convict of that lesser included offense of voluntary manslaughter. And I think furthermore, there's testimony that the victim in this case, Mr. Willingham, was the first person to shoot a weapon. Now, what I took issue with the Court of Appeals opinion was this sort of idea where the court sort of listed some of these facts and then says, well, distilling it down, Thille seemingly views Willingham's act of reaching for his hip during their quarrel as sufficient provocation to warrant a voluntary manslaughter instruction. Well, I would argue that that is really distilling it down. So it's to the extent that it's almost ignoring all of the other evidence at trial. Yes, my client did testify, and I would even argue that it is pretty much sufficient it is sufficient to warrant that instruction, because there was clear evidence that what he was reaching for, even though Micah said, I never saw the weapon, it's very reasonable and would have been a reasonable inference for the jury to make the inference that he was reaching for a gun. So, and subsequently, Winnie Hogan, who was another witness, said that when she attended the dead body of Mr. Willingham, the gun that he had in his holster was no longer there. So there's a holster on his hip on the deceased body. It's clear that he's reaching for the gun. So
are you relating these facts to the heat of passion instruction or to the imperfect self-defense instruction, or both?
I think they apply to both.
Let me try to break it down a little bit. I can understand the argument as to why they apply to the heat of passion,
Okay.
but under the requested, I'll call it imperfect self-defense instruction, isn't there a subjective element to that, lesser included?
Yes, I believe there would be.
And was there any subjective testimony, or was there any testimony about the subjective intent or state of mind of
Micah.
Is it Thille?
Yes, Thille. Yes, sir. Yes, Your Honor. I think there is some testimony to that.
Well, he didn't testify about it, did he?
He said that I didn't know he was reaching for his hip. And then he said that at that point I pushed him.
Didn't he testify that he did not shoot him?
He did say that he did not shoot them. He did not shoot him.
So how could there be any evidence that he did, from Thille himself, that he did shoot him out of this subjective belief?
I don't think there even has to be evidence from, just because there's other evidence.
Well, the evidence has to go to his subjective state of mind. And if he's saying, I didn't even shoot him, how could he ever have provided evidence of his subjective state of mind for why he shot him?
I'm unsure how he would have subjectively, but I suppose from an objective standpoint of the subjective question, that there's other testimony that the jury could have relied on. Clearly, the jury found. Do
you think it's possible to prove a subjective state of mind from circumstantial evidence?
I would say in this case that would be the argument. Yeah, that we have that here.
So the jury can infer from other evidence his subjective state of mind?
In this case, I would say that is a fair assessment. Yes. I suppose the other issue that I needed to cover today was
what about his conduct? I'm not so sure about the other witnesses providing credible evidence of a subjective state of mind of somebody else, but does his conduct help you at all when we're focusing on the imperfect self-defense? Is there anything about his behavior that gives us some indication, or upon which a reasonable juror could infer where his mind was at through the progression of this incident?
And I think that's what I'm driving at, Justice Wall, is that his conduct, everybody said the conduct was such that there's no indication that my client was necessarily it was yelling or screaming at him. I want to see Max. I want to get the bag back. At that point, the conduct from Mr. Willingham is to reach for his hip. And another witness said they heard him say something like, "What the hell?" So I think at that point, it can be inferred that he's at that point, making a show of force against my client. At that point, my client is going to be thinking, I need to defend myself. These are circumstances that I believe, honestly, in my subjective mind, that I need to use lethal force. Furthermore, there was evidence that when my client, Mr. Thille, pushed him away when he went to reach for that hip, at that point, there were shots fired. And there's testimony that the shots were fired at Micah and his girlfriend, Kayla, and that there were, Max also said that he saw, that he witnessed Mr. Willingham fire 2 shots. So from those facts, I think that it's pretty clear that even though Micah said on trial, I didn't shoot him. I mean, that's an inconsistent defense, but I don't think there's a problem with that. So because I think there is a lot of other evidence where we can say, look, he clearly, the conduct of Mr. Willingham would have caused Micah to have that subjective belief.
So you're saying the jury could have simply not believed Micah when he said,
Precisely.
I wasn't there.
Clearly they did that in this case because they convicted him.
And was that belief unreasonable? Does it have to be?
I'm sorry, Justice.
I mean,
This is what?
he may have held the belief. It sounds like you're making an argument for perfect self-defense, whereas the instruction would require that belief to be unreasonable.
Well, I suppose.
How are you threading that? You know?
It's hard to sort of divide this is because of the inconsistencies in everybody's testimony. So I guess there's two different ways here of what happened. I suppose it's not reasonable if he's only going to say, pull out his gun and say, please leave or something. It is then, on his mind, subjectively reasonable to act with lethal force if he's pulled a gun out and is shooting at him. So I think there's two different, do you understand? Does that answer your question, Judge Stoll?
I think so.
Okay.
Well, it's a sufficiency question, isn't it? If you give the voluntary manslaughter instruction and the jury says, yes, I believe there was an unreasonable but honest belief, then our review would be, is there sufficient evidence to support that?
Correct.
So we would have to decide then whether his belief was unreasonable or if there's evidence to support an unreasonable belief.
Right. And I would say that the evidence to support an unreasonable belief would just be the simple, as the Court of Appeals pointed out, or distilled down, was the only relevant or salient fact was that he was reaching for his hip. Just the reach for the hip would then be unreasonable. But I would like to, I mean, I really think that does apply in this instance, but the real more important, I guess, forceful component is the sudden quarrel, which is really what I focused on in the brief, and this fact that there is a immediate and sudden quarrel here when those two have this confrontation, either on the doorstep, just inside the doorway, or even in the house. And that's also a big question that this big issue in this case is there's really so much differing testimony that it's really hard for the court to hang its hat on something and say, no, I'm going to deny that instruction because this is what happened.
As I read the Court of Appeals opinion there, they went back to saying, but it doesn't qualify as a sudden quarrel because this was a very foreseeable altercation when Thille and his companions show up in the middle of the night. At least sorry, I'm drawing a blank on the woman who was with him, his name, but she was agitated. She wanted her stuff back. They were demanding, they wanted to see Max.
Right.
They were aggressive and agitated at that point. And so can you address that part, why they were wrong in that and the.
Thank you for that opportunity, Justice Lickert. I do want to address that. In that instance, so this idea of foreseeability, an unforeseen action being the nature of a sudden quarrel to sufficiently be of the legal provocation, I think that goes and ties in with this idea of it can't be some protracted thing. And I know the court cited State v. Lowry, which I didn't really think had any really bearing on this case because that was somebody that was being restrained, attempted to flee from like an attempted murder situation. And the defendant tried to argue that when they left, and that was a sudden quarrel. And so it's only voluntary manslaughter. So I think really the focus here is whether or not it's some sort of protracted thing. And foreseeable to the extent on some level, I don't see it being foreseeable that this would occur as far as I'm going to get a gun drawn on me. Micah didn't make any threats, that nobody testified to him saying, I'm here to beat you senseless if you don't, whatever, turn over my brother, if you don't give us this property back. He essentially just now, other people were agitated, correct? But there was really no evidence that Micah went to the door screaming at anybody other than just, hey, where's my brother? I want to talk to my brother. And at that point, Mr. Willingham reaches for a pistol. So I don't see this as being any sort of, there's no prior beef. In fact, my client said he didn't even know that Mr. Willingham lived there. So that's why I think this does fall into the category we submit of a sudden quarrel with legal provocation.
And your reliance on the harmless argument is that the no reasonable probability, the error affected the outcome in light most favorable in the entire record, but is basically what the jury did here.
Right, Justice.
That they rejected.
They rejected everything basically, but the least serious offense. And my argument there, which the Court of Appeals didn't address that either. They just said there's sufficient evidence of reckless conduct. So we're not going to find that being harm. That's not error. My argument is, yeah, but look at what the jury did in this case. They rejected, and that's the other thing, that there's this idea of you know, they gave alternative accounts for felony murder, burglary. I want to say it was burglary, which required a forceful entry. The jury rejected that. So the jury rejected all of these more serious offenses, landed on the least serious offense that they could find somebody culpable for Mr. Willingham's death. And I would argue strenuously that that's exactly what the jury would have done in this case if they'd been given, properly instructed on both voluntary manslaughter and involuntary manslaughter as well.
They would have gone even lower.
Exactly.
You're saying.
Exactly, based on the nature, and the Court of Appeals even recognized that in its opinion when it said that the involuntary manslaughter instruction should have been given due to the nature of everybody's differing accounts, the wide discrepancies in what actually happened, and the fact that all these people, almost all the witnesses, I mean, there's no testimony about Mr. Thille, but clearly everybody in the house, all of those witnesses were using drugs. So that's going to affect their perception, their credibility. And I think the jury at this point is throwing their hands up and saying, well, somebody's culpable here, but we're going to take the least possible serious conviction. Unless there's other questions, I'd yield the remaining. Thank you.
Okay, thank you. Ms. Chalmers?
May it please the court, the state appears by Assistant Solicitor General Natalie Chalmers. I guess I'll start with voluntary and then move on to involuntary. Is the state's position that essentially there was not sufficient evidence of sudden quarrel, a reasonable provocation that would allow someone to use self-defense. If this court is to say that you can break in essentially uninvited to someone's home at 3:30 in the morning and bring along 3 other people, scream and yell, push somebody, and then get to shoot them, that is incredibly dangerous precedent for basically anyone who ever wants to defend their home, because now I guess it's a free-for-all for all invaders.
Well, they're still criminally culpable, right? It's just a different offense that they're asking for.
They're still criminally culpable, but not nearly as much. I just don't think that any of the case law on heat of passion or reasonable provocation that this court has ever said, if you are invading someone's home, you can now pretend like you have some kind of justified right.
So I understand the argument. It seems in tension to me with the standard of review that this court has announced on these questions of sufficiency standard of review, essentially. In your mind, what would happen in this exact case with a little tweak, which is the heat of passion instruction had been given and the jury had returned a guilty verdict on that? And then it gets appealed. What happens on that from your perspective?
Lost cases when the judge has given heat of passion instructions over our objection, not in this exact scenario, but for say, when someone shot a law enforcement officer that was chasing them, lost that case at the Court of Appeals. This court didn't take review of it. Based on insufficient evidence, we've lost at least 2.
In other words, the evidence was too sufficient.
It was.
I mean, that's the tension of our standard of review, is it not? How does the state lose a case because they had too much evidence?
Well, no, the state lost that case because the Court of Appeals found there was insufficient evidence for heat of passion. They flipped the conviction and we just walked. No conviction at all.
I know, that's what I'm saying. How is that possible? I mean, I don't know what case you're referring to, but it sounds to me like you're saying that you lost a conviction entirely.
Yes.
Because the Court of Appeals said for the lesser included, there was insufficient evidence.
Yes, and that happens with heat of passion most frequently because there has to be an objective, reasonable provocation.
But you had sufficient evidence for the higher charge.
Yes, because
So just help me understand, like how is that?
The district court judge screwed up and gave an instruction that was unsupported by the evidence, and then the Court of Appeals said that lesser was unsupported by the evidence. As how it happened. I mean, you don't shoot law enforcement.
Yeah, well, that highlights to me the tension that I was trying to draw attention.
Right, and so because I think a lot of district courts, because this court has made such an easy standard to get.
So if I could summarize what you're saying, you tell me if this is correct. You're saying that it is in fact possible because of this court's standard of review on these things for the state to lose because they had too much evidence.
Oh, you mean we proved more than the lesser?
Correct.
Yes, because we
Or
absolutely.
at least there was, you didn't prove it because you didn't get
Well-
the conviction, but there was sufficient evidence for the,
Yes, the jury.
Had the
made
jury
kind of
convicted, there
compromise verdict. We had too much evidence that we could have gone on the higher.
okay.
But isn't that the function of a jury? Is to assess that evidence? If it's sufficient to support your more severe charge, but also the lesser included. Isn't that part, I mean, that's just our jury trial system, right?
That is, the only problem that hits typically is, and I actually go around and teach CLEs where I tell prosecutors to oppose heat of passion. It's the only instruction I say, depose, because we lose convictions, because then the Court of Appeals, I don't think this court has granted review in any yet. The Court of Appeals turns around and says there was actually not sufficient evidence. to
It
support-
strikes me that in the heat of passion context, appellate courts have made a pragmatic choice to construe sufficiency of the evidence as a legal question. Do you agree
Yes.
with that?
That is a legal question on whether or not it's, because it's an objective standard on whether or not there's an objectively reasonable.
In other words, they don't ask, could a reasonable juror have concluded that? They say, is it even legally possible?
Yes,
And that's this case, right?
yes. And I'm saying
The
no.
Court of
it's not.
Appeals said that it was not legally possible.
Correct.
Based on foreseeability, or are you suggesting based on the actual, or both, the actual way the incident unfolded and the foreseeability of it?
All the facts here, yes, both the way the event unfolded, the foreseeability, and then.
Is
as
there a
Justice
tension?
Siegel, sorry.
Oh, I'm sorry, but I'll go ahead. Is there some tension? So we are in the factual appropriateness prong.
No, I think
Correct?
you're in the legal appropriate.
Well, it is legally appropriate, isn't it? I mean, it's a lesser,
But it's still a legal stand.
but we are in the factual, I mean, that's my point. Is we're in the factually appropriate prong, but we have a legal analysis that essentially says, as a matter of law,
It's not factually appropriate. Yeah.
it's, as a matter of law, it's not factually appropriate.
Yeah, so.
Does
it
that
seems
make
like it should
sense?
Be slid over to the legal part.
Well, I don't know. I'm just
But
asking
that's,
for,
yeah, to me, since it's still a legal question, maybe the actual error is that it was. But it is still based on the facts though, but still, it's basically kind of like a summary judgment in any other case where you can prove all these facts, but you have no legal claim because those facts don't meet the legal standard. But what I was actually going to spin around and say is based on your earlier point, which was my response to the cross petition, the defendant here said he did not fire the shots. He has to have an unreasonable but honest belief. There is no evidence that he honestly believed that he was ever in danger. So I think that is the.
But aren't you, I think there's some conflation going on here between the self-defense and then the
Oh, you're right, I
sudden
switched.
quarrel, heat of passion. And I even think at the beginning you said that you know, when you made your introductory statement that you can just go into someone's home and, you know, based on self-defense. But if the core elements of whether the, you know, the factual appropriateness of voluntary manslaughter are an intentional killing, okay, and a legally, and this is objective, legally sufficient provocation. So it must deprive a reasonable person of self-control and cause that person to act out of passion rather than reason. So give me your best argument why the facts here don't establish that.
He broke into someone's home at 3:30 in the morning to,
Okay, it was on the doorstep at first, right? We're on
Right.
the doorstep.
he pushes in.
Well-
Again, 3:30 in the morning, he brings basically an angry mob to this person's house uninvited.
Well, so, but, okay, so this is your argument. Okay, go ahead.
I mean, that, he does, he brings an angry mob to this person's house uninvited and then shoots him twice.
Okay,
I-
but how are you showing that it wasn't acting out of passion? He just got so upset. I mean, is it your belief that this was premeditated?
I think the state charged that, but the jury went with reckless second, so I'm
I-
going in reckless second land. I'm not saying that the premeditation or not matters. I'm saying that you don't get to break into someone's home, enter their home, and then say, it's an objective, not subjective standard. I objectively have the right then to shoot this person who is trying to take some action potentially to defend themselves.
Right, but
It's
now
ultimate-
that's where you're conflating the self-defense. Because when you're just talking about
you're-
voluntary manslaughter, there is no self-defense. I mean, this is just, I went crazy.
But-
I wanted to see my brother. I went crazy. And, and it was just, you're not letting me see my brother, and so I shot him.
That is not a sudden quarrel, though. A sudden quarrel, and I think actually, Your Honor, with respect, you're conflating the two. The sudden quarrel has an objective standard. There has to be sufficient provocation. There wasn't here.
I'm not gonna let you see your brother. Get off my doorstep.
That is not, if we can now shoot people because you're denied entry into a home, that is incredibly.
Well, we're not allowing people to shoot people. We're trying to see the difference between whether something was reckless or whether somebody, just the heat of passion.
And again, that's an objective standard. It is not objectively reasonable to say.
Okay, so that's your bottom
said-
line.
Yes.
Not objectively reasonable to get out of control and passionate because you can't see your brother who stole something
You have-
from your sister-in-law.
You have, sure, you have to have legally sufficient provocation, and that just simply does not exist
Okay.
here.
Well, what about somebody shooting shots at you? And if we're viewing the evidence in the light most favorable to the requesting party, don't we have to consider the testimony that the victim fired the shots? And if some in the direction of the defendant? And if that is true, if I have the record correct, is that legally sufficient provocation?
I simply agree with the Court of Appeals that no, not here, not under this facts, not when you come into a house. It is reasonable to assume someone's going to defend themselves when you invade their home at 3:30 in the morning. I don't think we want to say that anyone can now say, well, I am going to invade someone's home. If the homeowner tries to defend themselves, I now have the ability to shoot them and I won't get premeditated murder or felony murder or anything like that. I can now get, felony murder actually.
Why doesn't that go against what you're saying? It's not reasonable. Isn't the fact that, is reasonable part of this? Well,
Yeah.
we're looking at, to be legally sufficient, it must deprive a reasonable person of self-control and cause them to act out of passion.
Well, to me, reasonable is an objective standard, and yes, you have, typically, I don't actually know of any case that the court has ever found heat of passion. It is one that you consistently say there is not sufficient evidence for.
Well,
The sufficient evidence is usually the textbook law school case is you caught your significant other in bed with another person, you lose control, shoot them immediately. If you have any time to think it over, typically this court has said, no, not heat of passion.
okay, but if someone shoots in your direction, and we're not talking about anything to do with self-defense. Okay, let's not conflate that, keep that over there. But just someone shoots in your direction and you just get out of control and just
I don't
lose your,
think you're out of control at that point. Actually, I think that's
Really?
a rational reaction to being shot at is to maybe return fire.
Is one of the elements the jury has to decide is whether there is an objectively reasonable situation.
Right.
So aren't you really asking us to reweigh the evidence? Because you don't think it's objectively reasonable.
I think a reasonable person doesn't think it's objectively reasonable. And if you're.
So
anytime
you're
the word-
reasonable, but the jury is not.
The jury didn't do anything here. So I'm not fighting a jury verdict.
But you're saying there is no objectively reasonable situation, and I'm afraid I'm going to lose if I give that instruction. So I don't want the jury to be able to decide that,
I'm saying that
because they might be wrong.
if the jury comes back and says yes, that this court or the Court of Appeals will vacate that conviction because there is not sufficient evidence. Because an objective standard is something, this court, you're all objective people, you get to make that decision. It doesn't involve reweighing evidence. It's a legal standard at that
The
point.
exact Court of Appeals panel that heard this case would have vacated that conviction.
Yes.
That's
They would have
exactly what they
vacated-
said, correct?
Yes, they would have vacated the conviction if we had given that. And that's why we fight these, is because we will lose potentially everything.
But it's
Um,
also
Is
a
that right?
situation.
I mean, the Court of Appeals said they would, is that the correct result here? I mean, I guess are you asking us to revisit our long line of cases, which some took exception to regarding 22, 34, 14, and what reasonably justify a conviction means? And we've applied over the last 10 years
Sufficient evidence standard?
What are you asking us to do? Is that what you're asking us to do?
I think this was correctly decided under the current standard. Would I like you to revisit that? Yes. Did I brief that though? No. I think that Your Honor, in your cases where you've dissented or done concurring opinions where you've said that standard is not the right standard and we could go back to before that standard, I would love that, but that's
No,
not what I
forget that.
briefed.
That's long. Yeah, but so you're not asking us to do that. You're asking us to apply the standard and it doesn't.
Yes, I'm saying that apply the standard the way it's been applied for the last 10 years.
You're saying
The
that
end result-
viewed in it, sorry, go ahead.
The end result of that, though, would you agree, gets to some of the questions you were taking from the other side of the bench, which is that in fact, it takes the reasonableness question away from the jury. It's exactly what it does in this case, right?
It does, but it's because it's a legally objective standard. And
I understand, but isn't that driven by our standard of review? In other words,
still has the
this-
sufficiency of the evidence standard.
right, we have a sufficiency standard which drives the question of whether this is a question of law or a question of fact. And because we want to avoid the circumstance that you've described, we treat the reasonableness question as a question of law.
Yes.
We have as flips of how we look at the evidence, one of those two tests. In terms of looking at the instructional issue, we look at in the light most favorable to the defendant, is there evidence to support it? But when we look at the sufficiency, we would look at it in the light most favorable to the state. Does that cause the collision of results potentially here that we're struggling with? Where it might be appropriate to give the instruction to the jury, but then it might not meet the sufficiency standard?
It should across the board meet the sufficiency, because if it's in the light most favorable for the defendant and he somehow gets that, it should also be in the light most favorable to the state.
That's what I would think. So why, I guess I'm trying to figure out how we get the inconsistent results.
I think because it,
Or
well-
the results that seem to be in tension. maybe
Right,
it's Not inconsistent.
I still am of the opinion that in the cases where the Court of Appeals flipped those convictions, the district court is the one that messed up, not the Court of Appeals. Because the district court found there was sufficient evidence for a jury instruction, there was never sufficient evidence for. But here though, I think
Because the evidence has to meet a legal threshold in
Yeah.
order to sustain the conviction. And that's your argument, is that even viewing the evidence in the light most favorable to the defense, it just doesn't cross that threshold that they have to get across the legal threshold of adequate provocation. And maybe foreseeability is a separate doctrine, I don't know, or if that feeds into the same standard.
exactly, Your Honor. And not sure if I should transition now but even if the instruction should have been given, I do think harmlessness comes into play here too, because again, the defendant said, I didn't shoot him. There's no suggestion that he did so because there was this quarrel involved, or I absolutely can't figure out how that he would be able to get an unreasonable but honest belief. So even if you're convinced in the light most favorable defendant, the actual evidence here would make any error harmless.
This is a little unusual in that we do have that statement from the defendant, but obviously the jury didn't believe the defendant.
Yes.
So given those circumstances, can we just set that aside and just then look at the totality of the evidence to see whether or not he would be entitled to it as we look at the facts and the other people's testimony?
I think you can for the sudden quarrel. Like that's pretty easy to do, look at the facts. My problem with doing so when there is such a subjective, like imperfect self-defense, voluntary manslaughter is entirely subjective. You basically knocked out the objective prong and it's subjective. And he has to have an unreasonable but honest belief. I don't know how you get into whether a defendant honestly believes anything without a defendant saying this was my honest belief. So I do not think there's sufficient evidence of an honest belief here of any kind. And if in fact he suddenly has the right now to shoot back when someone is trying to defend himself, I don't see how that's unreasonable either. So I do not think that legally he can get unreasonable but honest, but if somehow this court disagrees, I would say no reasonable jury would get there. On the reckless one, I realized I cross petitioned. Oh, I'm sorry, do you want me to talk about that?
Yeah, I'll go ahead if you would. I think we're interested in that and we've asked several questions.
On the reckless one, I realized I cross petitioned and then didn't brief how much I am not a avid fan of the standard of review. So that was probably some mistakes that I made. But I don't know how essentially there are facts supporting mere recklessness. Here, if in the light most favorable to the defendant to get recklessness, he's essentially firing a firearm in close proximity, either an inch to 3 feet away from a person twice. And to me, that's just recklessly under circumstances manifesting extreme indifference to the value of human life. So
The problem I'm having with this whole discussion, is if the case is as you portray it, you would have won you would have gotten a better conviction, but they did not convict on those other crimes. And so they've rejected that. And given that, I'm having a hard time figuring out why I get to go back into those facts and use them against the defendant in this context. And it applies to the this other issue as well. This jury just, from your perspective, went off the rails.
I mean, anytime you fire a gun and hit someone, at minimum, you have reckless, but
It went off the rails, and and so that's the trouble. It'd be so easy to say, well, he said he didn't shoot him, so all of that should go out the window, except they didn't buy it.
they did found he didn't shoot him, or that he did in fact shoot. So we know the fact we know is the jury found that he killed him and that he didn't do so intentionally, essentially. And the reckless involuntary versus reckless second degree murder, we are in clear error standard. So now the defendant gets to have the burden to prove that the jury would have convicted of the lesser reckless. And it's my position that a reasonable jury would not do that here because he fired 2 shots in close proximity. That's not just recklessness. That is extreme indifference to the value of human life. And I don't think I have anything else to add.
I have one more question, and I know you probably can't do this off the top of your head, but I am very curious to know the name and site of the case that you were talking about with the Court of Appeals.
Yeah, can I provide a 609 letter? Would that be okay?
Right.
Or
That's fine.
That would, yes,
Okay.
you may.
Oh,
Do you-
sorry.
And
no,
then
yeah.
Not in charge of that.
Rediger will have an opportunity to respond if
Okay.
you.
I'll just cite the case with no argument if that's okay. All right, thank you so much. The state would press the earphone.
Mr. Rediger?
I think I just wanted to touch briefly on one point that you made, Justice Stiegel, about this sort of inherent tension that we have when we're doing this analysis of, okay, we think it's a clean divide between legally appropriate, factually appropriate, and then how once we're into the factually appropriate, we're starting to talk about legal principles. Well, that's exactly what the jury's for. They're instructed to take the facts that are in evidence, apply the law that's given to them.
Yeah, I'm sympathetic to your argument that the way we do this arguably takes the reasonableness question away from the jury.
Right. So that's
Is that essentially what you're?
essentially, yeah, that's the function of the jury. And that's the point of making this case, is that there was so much different evidence and so many different versions of this story that this is the perfect case where if it's a legally appropriate instruction, we're going to give it to the
So-
jury and let them sort it out.
I'm glad you brought that. That sort of is the last hanging chad, if you will, at least in my thinking on this case, which is, the Court of Appeals definitely treated this as a factual appropriateness question. In fact, they just kind of gloss over legally appropriate by saying, well, if it's a lesser included, it's legally appropriate.
Correct.
Is that true in our case law? In other words, when you have a lesser included that has an added element, have we always said it's legally appropriate, or do we have to analyze that added element?
And which added element?
Well, the added element of a legally sufficient
Legally
provocation.
sufficient provocation.
I mean, I'm not for sure. That's why I'm asking the question. I think some of our older case law treats that question as a legal question and analyzes it under the legal appropriateness problem.
Your Honor, I can't say that I have a,
Would that make sense? If you don't know, that's fine.
I don't know.
Would that make sense to you?
I mean, it could make sense, yes, to be fair, yes. So I don't know if the court has any additional questions for me. I guess one other thing I want to touch on too with you, Justice Stanridge, was this idea of just, okay, yeah, and that's the argument I made, this is a sudden quarrel. I didn't have any prior beef with this. My client didn't have any prior beef with this guy. There's no ongoing thing. It just found out that his brother is in this place. He's also the same place that my brother keeps going to get high. And he's supposed to be in court in the morning. Now, I know a lot of that didn't come out, but I mean, that wasn't ever testified that, hey, I went there because of that. But I think it's something that the jury, and that was part of the entire testimony in the evidence trial. So that also adds to this sudden, he lost control. I think it just makes a lot of sense, and that he didn't, this isn't just I'm barreling through your front door, some home invasion. I went to the front porch, wanting to know where my brother was, wanting to know why you're still selling drugs to my brother. So I think that is a sufficient legal provocation in this case to justify that.
So factually, you're saying that the evidence could justify this scenario that he's there with his group on the porch and he just went in to get his brother. Did he break in? Did he break down the door?
The testimony again varies. Some
Right,
witnesses
but
say
is there
that,
evidence that he did not break down the door?
yeah, there's plenty of evidence that he didn't break down any door. There's testimony that Mr. Willingham, the victim, came out right away, opened the door and said, "What the hell?" At that point, it seems to be a reasonable inference then that he was then reaching for his hip, like, I'm just going to go ahead and shoot you right now. There's also testimony from one of the witnesses that said that Micah just, the door was open or something, and he just walked right in, and Mr. Willingham was poking his head out the door. It's just all over the place, frankly. So it's difficult to even, and that's where I come back again to due to that. And the Court of Appeals even recognized that when they said that I should have given the involuntary manslaughter instruction, that based on all the divergence between the testimonies and what really happened here, we had to just kind of turn this over to the jury and let them sort it out. So that's where I think the error was in this case by the Court of Appeals and the district court. We just asked the court for a reversal, and I think the court for its time this morning.
Thank you. Thank you to both counsel for your arguments in this matter. The court will take this case under advisement